You are watching continuing coverage of the Trump election interference hearing since the Supreme Court's immunity ruling that is taking place here in Washington right now. Judge Tanya Chutkan presiding over this, going back and forth with Trump's attorney in court right now. And I want to go out to Paula Reed very quickly because, Paula, I know you have been following these updates coming out of the courtroom from our reporters who are inside doing amazing work, feeding us exactly what's going on. What's the crux of what we've been hearing so far? It sounds like a pretty lively exchange between Judge Chutkan and Trump's attorneys.
Yeah, it's getting a little spicy in there, Jim. I'm reading these live updates from our colleagues here on my phone, and the Trump team got up. It's their turn, and they're being pretty dramatic. And we know that sometimes the defense attorneys, they need to play to an audience of one. And I say they're dramatic because some of the things that they're saying in court right now just do not match what are in their filings. We know from the joint filing between them and prosecutors that, look, they don't agree on everything when it comes to scheduling, but they're also not that far apart. But here, the defense attorney got up and said he could not imagine a more unfair protocol than what the special counsel is suggesting going forward. Now, the judge clearly doesn't agree with that, but the defense attorneys also argue that the Supreme Court has already decided whether prosecutors can use evidence around Vice President Mike Pence. And the judge cut him off and said, I would disagree with that. And this is significant because this is really going to be the next area of dispute between prosecutors, defense attorneys, and clearly the judge. The judge here noting that it is up to her. The Supreme Court has given her discretion on this issue. So it's clear this may not go exactly the way the defense attorneys hoped, but their number one goal here today, Jim, is to just delay anything of substance until after November.
Yeah, I mean, Paula, were Trump's attorneys expecting Judge Chutkan to just come in today and say case dismissed?
Absolutely not. Look, they do believe that she is fair, but this is someone who is tough. She has a command of her courtroom. Yeah. She comes in prepared, and she does like to spar a little bit, both with prosecutors, but probably more so with defense attorneys, because again, sometimes they come in and they say things more for their client. Yes.
Yeah, and Laura wants Chutkan to decide whether this new indictment is legitimate. I mean, that is interesting. So we're certainly getting some details coming in real time. We want to continue to go over those. Paula, forgive me for interrupting. I want to go to former Trump impeachment attorney Michael van der Veen. He is with us as well. Michael, I don't know if you've been following along some of these updates coming out of the courthouse from our reporters who are inside Judge Chutkan's courtroom, but it sounds as though there's a lot to untangle here, but Judge Chutkan is pressing forward.
Yeah, you know, she's in an interesting position because this isn't the kind of case really any judges had to handle before. But she's going to really have to try to parse out from this new indictment what types of evidence can come in and what types of evidence can come out. And I think that the more you get into the weeds on that, I think the more you're going to see barring in the courtroom.
Yeah, and just a few moments ago, Judge Chutkan said she has to decide whether the conversations that were going on with former Vice President Mike Pence and so on were outside the bounds of official presidential conduct. Michael, it sounds as though the crux of this case is going to be, and some of this is going to get sorted out, it sounds like, from the judge before we even get to a trial, which actions from the former president, then President Trump, were considered official acts of the office of President of the United States, and which actions were those carried out by somebody who was trying to get reelected. Michael, you still there? You froze for a sec.
Yeah, no, that's absolutely right. They have, set up several different buckets of evidence. What were official acts and what are private acts, and the official acts evidence will be admissible and the private acts evidence won't. But, how you differentiate between the two is going to have to do with the timing of evidence being created, the conversations and whatnot, and who else was involved.
And Ellie, this is important right here. You were just saying that this argument that is going to be happening over filing briefings on immunity and so on, this is key.
Yeah, so Trump's lawyers just said we need a full and robust record, and Trump's lawyers just said we need an evidentiary hearing, meaning we want live witnesses. I actually thought it would be the opposite. Right, and the complaint that they made earlier, we talked earlier about grand jury transcripts, right? The prosecutors have said, well, we would like to submit grand jury transcripts and attach them to our briefs.
And it says, Lauro says they were not suggesting the case should go into the fall of next year, but that the issues at hand need to be dealt with carefully.
Right, so he wants a slowdown here.
He
wants a hearing, but certainly not before the election. But what Trump's team is saying is we're not satisfied with grand jury transcripts because they're one-sided. It's only the prosecutor asking questions of the witnesses. There's no defense lawyer. There's no cross-examination.
And they feel, Trump team feels as though the judge is going to dismiss this case once they see their filings. The judge says that immunity needs to be dealt with as early as possible.
Yeah, I'm skeptical of the first part of that. I don't think the judge is going to throw the indictment out.
Yeah.
But yeah, I mean, look, the judge clearly wants to deal with this, and they recognize they have a long road ahead. Trump's team is trying to slow it down, and the judge seems aligned with prosecutors here to let's move as quickly as we can.
Yeah. Michael, I mean, you would agree that the Supreme Court has given Judge Chutkan a lot to unpack, a lot to untangle. This case becomes very complicated, does it not?
It certainly does. I mean, procedurally, you're going to have motions to suppress under constitutional grounds, and now under this Supreme Court decision, you're also going to have a lot of motions in limine on evidence. There are, it's not going to be one evidentiary hearing. It's going to be days and days for really to go through all of the evidence that they want to use. I know they cut out a lot in the indictment. They also left a lot in it.
Michael, is that a good idea for Trump's defense team to want an evidentiary hearing, particularly before the election?
Well, those are two different things. There are two different considerations there. One is the legal system and being his criminal defense lawyer, and the other one is he's in the end of a campaign, and that's the balance his lawyers had to fight all of the time. But they need to know what evidence that they think the judge is going to let in to then craft other motions from there. So they got to have a hearing, and if they could have it afterwards, of course. But they also need to move with the pace that the court requires.
Yeah. And Trump's attorney is saying it is inherently unfair and inequitable process for prosecutors to immediately file immunity arguments. Ellie, I mean, Trump's team and Donald Trump, they've been playing this delay playbook for months now, years now, and they want to continue it.
Well, they've already largely succeeded by evidenced by the fact that we're not going to have a trial between now and the election. But it's important to understand what's happening here. Prosecutors are saying, let's get the immunity arguments started quickly. We want to submit the first brief within 2 or 3 weeks. We're going to attach grand jury transcripts to show the world what's been said and testified to in the grand jury. And Trump's team is saying, oh, no, we don't want that. That's one-sided, and we want it to happen much more slowly
and
than that.
And the judge is saying there's nothing inherently violative of due process to have the prosecution's timetable here.
And what John Lauro says here is exactly what I just said.
He's going back.
Incredibly Trump's unfair. Lawyer, incredibly unfair that the prosecutors, are able to put in the public record evidence against Trump at this time.
So they don't want the prosecution to put evidence into a filing at the court before the election. That's apparently what Trump's team is saying right now.
Yeah, and in the papers leading up to this, Trump's team said we shouldn't even dig into the immunity argument until December.
Karen, why is that important? If I can get a quick thought from you before going to break.
Yeah, it's important because if you are immune from prosecution, that's a threshold question. It means you cannot be prosecuted. It means you're not guilty. And so what they're saying is that would be prejudicial to put all this stuff out there.
And Karen, I'm sorry to interrupt. Trump's attorney just suggested it's too close to the election, according to our reporter side panel. And Judge Chutkan says, in response to that. Maybe it's too long of an as I'm reading it there, but she says, in response to that. Go ahead, Karen. And the judge says, I understand there's an election impending. Go ahead. Sorry about that, Karen. Go ahead.
No, really, that's what she was trying to get them to say on the record, that the whole reason, there's no reason, for example, in a criminal case to delay things as long as Lauro, Trump's lawyer, wants to delay them. And so that's why she keeps asking and pushing them, why are you asking for this timetable? And they finally admitted it's because of the election. She just wanted to put that on the record because she doesn't think these issues will take that long.
Yeah, she says, you've said before, and I will say again, that the electoral process of what needs to happen before the election does not matter here. So Judge Chutkan, if folks thought she was going to cool her jets after the Supreme Court and what they decided, not so much.
Yeah, she's made clear that, and she's made clear from the start that she doesn't care about the election. We can argue whether that's a good thing or a bad thing, right or wrong for a judge, but she's using Trump's own position against him, saying before you were sort of insistent that we shouldn't do this before, you're still insistent we shouldn't do it before.
She says this court is not concerned with the electoral schedule.
She has said that many times before.
This court.
Right.
Yeah.
True. Interesting.
Very interesting choice of words there from Judge Chutkan.